Welcome back, everyone, to the deep dive. Today, we're gonna be looking into a an interesting situation.
Yeah, a bit of a sticky one, this.
Yeah, a public service employee in South Africa got dismissed for basically being AWOL, right?
Right, it's gone. Yeah, it's a specific legal term.
Absconding. But they're claiming they didn't abandon their job. It was more like they were forced out because the workplace was just completely intolerable.
Exactly. And the really intriguing part,
Yeah.
this employee is pointing the finger at the SSA.
Whoa. Okay. The state security agency. So we're talking serious allegations here.
Absolutely. To really unpack this, we've had to dig through legal analyses of not just abscondment itself, but also constructive dismissal. Then there's employee rights, obviously constitutional rights in South Africa, and then a whole bunch of relevant case law.
Oh, wow. So this is a deep dive in the truest sense of the word.
It really is. And our goal is to see if, based on all this information, this dismissal could actually be considered legally unfair.
Right, right. So much to untangle here. So let's start with, I guess, the foundation, the basics. When we talk about absconding in South Africa, what exactly does that mean? Like, legally speaking, under their labor laws and the Public Service Act specifically.
Okay, so abscondment, it's basically when an employee is away from work for a long time without permission, and the employer can reasonably assume they have no intention of coming back.
So it's different from just like calling in sick for a day or two.
Yeah, it's way more serious than that. It's not even like desertion, where the intent to quit is pretty clear. For public service employees, the Public Service Act actually spells it out. If someone's absent without permission for more than a month, a whole calendar month.
Oh, wow. So a month is like the magic number.
It's in Section 17(3)(a) for employees who don't have specific rules laid out for them. But it's not just about the time. There has to be evidence that the employee doesn't plan on returning.
Right, so like a paper trail or something.
Exactly.
Yeah.
There's a case, Wemthree and Capital Caterers, that really highlighted this need to show the employee had no intention of coming back. And while a labor court in South Africa has mentioned 30 days straight as a benchmark, employers can't just jump to conclusions.
They can't just say, oh, you've been gone a month, you're fired.
Nope. They've got to try, contact the employee, maybe send a warning letter. You know, there's this case, South African Broadcasting Authority, VCCMA, that showed how important those steps are.
CCMA?
The Commission for Conciliation, Mediation, and Arbitration. They basically handle labor disputes. And they require solid proof that the employee wanted to ditch the job.
And that the employer actually tried to find them, right?
Yes, exactly. And there's another case that speaks to this, SEMA v. General Public Services, Sectoral Bargaining Council, and others. It really hammers home the point that employers got to make a genuine effort before they can just label someone as absconded. Now, there are some super specific situations where they might not need to do all that, but those are rare.
Okay, so what about this employee's claim that they were basically forced to leave because the work environment was unbearable? Is that even a thing legally?
Absolutely. That's what we call constructive dismissal.
Right, I've heard that term.
It falls under Section 186 of the LRA, the Labor Relations Act. So even though the employee technically resigns in a constructive dismissal situation, the law sees it as them being pushed out.
So it's like a disguised firing?
Pretty much.
Yeah.
But the conditions have to be really bad, like objectively bad.
Yeah.
So bad that any reasonable person in that situation would feel like they had no choice but to leave.
So not just like, oh, my boss is kind of...
No. We're talking about abuse, humiliation, bullying, maybe unsafe working conditions. It's going to be a toxic environment, and the courts have backed this up. There's a case center for autism research and education, CCMA, that really demonstrated what a toxic workplace can look like.
So if this employee is saying the SSA was involved somehow making the work environment scary and hostile, could that be seen as intolerable enough to justify leaving, even if they didn't officially report it through the usual channels?
That's where things get even more complicated.
Right?
Because normally employees are expected to go through their company's grievance procedure.
Like report it to HR or something?
Exactly. Like in Murray v. Minister of Defense, they talked about that. But there are exceptions.
Like what?
Well, if going through those procedures would be completely pointless, or if the problem's actually coming from higher up the chain of command.
So if the employer is part of the problem?
Yeah, or in this case, if a powerful agency like the SSA is allegedly involved, it could fall under those exceptions. It's not a clear-cut situation at all.
Right, and that brings us to the whole issue of this employee's rights, you know?
Right.
What does the South African Constitution say about protecting employees in a situation like this?
Okay, so the Constitution has a lot to say about fair labor practices.
Like how so?
Well, Section 23(3) it guarantees the right to fair labor practices, which includes protection against unfair dismissal and the right to a respectful work environment. So forcing someone to resign because of intolerable conditions, that could be a violation right there.
What about this whole surveillance angle? I mean, if the employee was feeling harassed or intimidated.
Well, Section 10 of the Constitution guarantees the right to dignity. And if what the employee is alleging is true about the SA's involvement, that could absolutely be seen as an infringement on their dignity.
And what about their right to actually feel safe at work?
Right. Well, Section 24, that's the right to a safe and healthy environment. And that includes mental well-being. So if the SSA was creating this atmosphere of fear and intimidation, that would clearly go against that.
Okay, so let's talk about the elephant in the room here.
Right.
The SSA. What business would they even have getting involved in a regular public service employment situation?
That's the million-dollar question, isn't it? From what we've seen in the legal analysis, there's no clear legal basis for the SSA to be meddling in a typical labor dispute. Their job is supposed to be about national security threats, terrorism, sabotage, that kind of thing. That's all laid out in the Intelligence Services Act.
So they're not supposed to be the workplace police?
No, not at all. Now, the LRA, the one we talked about before about labor relations, that doesn't actually apply to SSA members themselves. But this employee, they were a regular public service worker.
So the SSA overstepped their boundaries?
Possibly. And there's been a lot of talk about the SSA and whether they've always stayed within the lines. There was this big report, the high-level review panel report on the SSA. It brought up some serious concerns about them getting involved in politics and acting outside the law.
So if it turns out the SSA did create this awful work environment for this employee and it led to their dismissal, could that be considered unfair under the law?
It's very likely, especially if the employer knew what was going on and didn't do anything to protect their employee. That would make it an unfair dismissal under the LRA, almost certainly.
So even if the threat is coming from outside the workplace, like from the SSA, the employer still has a responsibility to keep their employees safe.
Absolutely. The Occupational Health and Safety Act, or OHSA, it makes it very clear that employers have a duty of care to provide a safe and healthy work environment. And that doesn't just mean physical safety. It includes mental well-being, too.
So if the employer knew about this situation with the SSA, they had to step in.
Exactly. And there's another layer to this. What if all this stress and fear led to mental health issues for the employee? That could be a whole other type of discrimination.
Unfair discrimination because of a disability.
Yes. The Employment Equity Act, or EEA, and the Code of Good Practice that goes with the LRA, they both talk about how important it is to accommodate employees with disabilities, and that includes mental health conditions.
And has this come up in court before, the whole mental health aspect?
Oh, yeah, definitely. There's a case, Sanlam Life Insurance, LTDV Mogomatsi, that really emphasized how important it is to consider mental health in these kinds of situations. And the Labor Appeal Court has made it clear that mental health is a crucial factor in dismissal cases.
Wow, so we've talked about a lot of legal stuff here. Are there any specific cases that really show how pressure from outside groups can lead to an unfair dismissal?
Oh, yeah, there are a bunch, like East Rand Proprietary Mines, LTDV, UPUSA, and Laboa Platinum Mines v. Hill. Those cases really emphasize that employers can't just cave to pressure from a third party without trying to figure things out themselves.
So they can't just do whatever someone else tells them to do?
Nope. They have a responsibility to their own employee. And there's another case, White versus Pinnacle Point Investments. It shows how important it is for the employer to do their own investigation before taking any action.
So even if there's pressure from a powerful group, the employer still has to be fair.
Right. And this is important even when it comes to the SSA. There's a case, MFV, State Security Agency, and others, and it showed that even the SSA has to follow the law. They can't just do whatever they want.
Wow. Okay, so to sum all this up, if this employee can prove that they were forced to resign because of the SSA and that their workplace became intolerable and that their employer knew about it but didn't help them, then their dismissal could be reversed, right?
Exactly. It could be considered an unfair constructive dismissal.
Yeah.
And because it involves constitutional rights, it becomes an even bigger deal.
So the key takeaways here are that being forced to resign because of intolerable conditions, especially if it involves something like the SSA, that's a huge red flag. And employers, they have a responsibility to protect their employees even if the threat is coming from outside the company. And all of this is backed up by a whole bunch of legal precedents.
Couldn't have said it better myself.
This whole situation really makes you think, doesn't it, about the balance between national security and the rights of everyday people.
It definitely does.
What happens when those two things clash? How do we make sure that people are protected? That's something we all need to think about. Thanks for joining me for this deep dive. It's been really eye-opening.
Absolutely. Thanks for having me.
Until next time, folks, stay curious.